Supreme Court allowed the appeals in the matter of PERIYAMMAL versus V. Rajamani and others and set aside the judgment passed by High Court and order of executing court. Supreme Court directed all the high courts across the country to call for the necessary information from respective district judiciary as regards pendency of the execution petitions. Once the data is collected by each of the high court shall thereafter proceed to issue administrative order or circular directing the respective district judiciary to ensure that execution petitions pending in various courts shall be decided and disposed of within 6 months period without fail, otherwise concerned presiding officer would be answerable to High Court on its administrative side. Once entire data along with figures of pendency and disposal is collected by all the high courts, the same shall be forwarded to registry of court with individual reports. Following issues were to be dealt in the matter: whether the courts below committed any error in upholding objections raised by respondents 1 and 2 against execution of decree on claim of being in possession of suit property in their capacity as cultivating tenants, whether respondents 1 and 2 were entitled to protection of Tamil Nadu Cultivating Tenants Protection Act 1955, and could the executing court have decided question of validity of decree on this ground. Supreme Court said that it is a settled position of law that an application under Order 21, Rule 97 may be made in respect of obstruction raised by any person obtaining possession of decretal property. The courts adjudicating such application have to do so in accordance with Rule 101 and hold a full-fledged inquiry to determine all questions, including questions relating to right, title, or interest in the property arising between the parties. A conjoint reading of the relevant provisions and principles laid down by the court make it clear that in execution of decree of possession of immovable property, executing court delivers actual physical possession of decretal land to the decree holder. Rule 35 confers jurisdiction on executive court to remove any person who is bound by decree and who refuses to vacate the property. The words any person who is bound by decree clearly mandate removal can only be of a person who is bound by decree. Rules 97 to 101 deal with situation when execution is obstructed or restricted by any person claiming right, title, or interest in the property. The words any person include even a stranger to decree resisting decree of possession as not being bound by decree or claiming independent right, title, or interest to the property. Rule 97 not only provides remedy to decree holder in obtaining possession of immovable property, but also to stranger who obstructs or resists delivery or possession of property by claiming derivative title from the judgment debtor or independent right, title, or interest in decretal property. Rule 99 gives right to third party claiming right, title, or interest in property to seek restoration of decretal property. Suffice it to say that remedy under Rule 99 is available when a person claiming right to decretal property is already dispossessed. Rule 101 enjoins upon executing court dealing with application under Rule 97 or 99 to determine all questions, including questions relating to right, title, interest in property arising between the parties and relevant to adjudication of application. As held by Supreme Court in Silverline Forum, the question that the executing court is obliged to determine under Rule 101 must possess two adjuncts, with that such question should have been legally reasoned between the parties, and such question must be relevant for consideration and determination between the parties. Upon adjudication of such question, executive court is under obligation to pass appropriate order as contemplated under Rule 98 or 100 as the case may be. When eventually such order is passed, it would be treated as decree and no separate suit would lie against such order. It therefore follows that the only remedy is to prefer an appeal before appropriate court against such deemed decree. Under Section 47 of CPC, all questions relating to execution, discharge, or satisfaction of decree have to be determined by executing court, whereas under Rule 101, all questions, including questions relating to right, title, or interest in property arising between parties to proceedings, have to be determined by executing court. Section 47 is a general provision, whereas Order 21, Rule 97, and 101 deal with specific situation. Moreover, Section 47 deals with executions of all kinds of decrees, whereas Order 21, Rule 97, and 101 deal only with execution of decree for possession. Apart from that, earlier, prior to amendment, every order falling under Section 47 was appealable, as the terms decree included the order under Section 47 of CPC, whereas now only certain orders, as provided under Order 21, have been made appealable. High Court and Supreme Court had affirmed the decree of specific performance with possession in favor of appellants in year 2004 and 2006 respectively. Subsequently, sale deed was executed by executing court on 17 August 2007, thereby transferring title of suit property to appellant. Despite such confirmation of decree and transfer of title in favor of appellants, it is incomprehensible why a notice was sent to vendors by revenue authorities in 2008. Further, vendors gave no objection to grant of certificate of possession to respondents 1 and 2 from 1974, despite not having any authority to do so in light of sale deed dated 17 August 2007. Certificate that they are in possession of suit property since 1974 does not come to their aid. Supreme Court said we say so because the said certificate does not establish any independent right of possession in favor of respondent. The certificate itself appears to have been obtained in collusion with the vendors who at the time of giving no objection had ceased to be the owners of the suit property. There is no question of deciding validity of decree on ground of being a nullity due to lack of jurisdiction of civil court to evict cultivating tenants. Court concluded that High Court committed egregious error in passing the impugned order. We must now ensure that appellants are able to reap the fruits of the decree. We are also of the view that rejection by High Court of amendments to execution petition filed by appellants was erroneous and deserves to be set aside. Court thus held that the executing court shall now proceed to ensure that vacant and peaceful possession of suit property is handed over to appellants in their capacity as decree holders and if necessary with the aid of the police. This exercise shall be completed within period of 2 months from today without fail.